The defense team in the Richard Allen case has filed a motion to correct errors. But a little bit closer of a look lets me think this may not really be a motion to correct errors, but this really might be a situation where they're filing it for timing and tactics. Let's jump right in. This is a long, drawn-out case, probably the most famous case in Indiana's history. 2 young girls senselessly killed in Delphi, Indiana. Case sat cold, unsolved for years. There's arrest made. Person arrested kind of looks flimsy at first, but then there's confessions, so many things going on at once. But there are some other people that may be involved, allegedly. Odinous, some people I don't want to name because I don't want to get sued. One of the names is a guy named Ron Logan. Ron has passed away, and he's part of this, but he's also kind of pointing that. And, we have these people that may have been involved. Trial judge shuts it down. Trial judge basically said, hey, yeah, there's a dead body, 2 dead bodies, and you can't point the finger at anybody else, but we're going to give you a fair trial. And I didn't hear all the evidence. That probably was the right ruling by the trial judge. I have no idea, but seemed kind of odd. Lots of people in the defense community. As predicted by yours truly, he lost the case because, again, he wasn't able to point the finger at anybody else. So, guilty, sentenced about 30 days ago. Motion to correct error is filed within 30 days of the sentencing. Now, motion to correct error is not a very common thing after a jury trial. Yeah, people file it. I've filed quite a few of them myself. But in civil cases and in criminal cases, if there's a jury trial, you're asking the judge to undo a verdict rendered by a jury of one's peers based on paper filings. And while theoretically it's possible, it's not very likely. I have seen motion to correct errors be successful with a bench trial, just a judge. Usually for civil cases, hey, judge, you ruled this way, my client lost. Here's some additional case law, why we think you were wrong. Oh, here's some additional new evidence I would like for you to consider. That does happen. Sometimes with criminal cases, maybe there's some sort of new evidence discovered within 30 days of the sentencing, and you have to get that in motion to correct errors, otherwise Court of Appeals won't consider it. But it's not very often you file a motion to correct errors in a criminal jury trial. It's just not. They did file it. And the motion to correct errors says, hey, there's new evidence. There's lots of things in these motions, lots of argument about rulings and whatnot. But the 2 big things are, hey, there's new evidence that Ron Logan did the crime, and there's new evidence about our expert. But when you look at this, it's not really like new evidence. They had this stuff, but based on the trial testimony, the evidence they had could be interpreted in a new light. I've not done the research on motion to correct errors. I don't think that's how that works. But I do think there might have been a reason why they did this, even if it's not the normal way or the preferred way. Now, there's 2 things of new evidence that they say exist. The first one is Ron Logan. Ron Logan, he's involved with this case. Maybe he didn't do it, but his property is near. He was originally a suspect. There are search warrants on Ron Logan. And when they couldn't get him for this actual crime, they violated the hell out of his probation around this time. They put him in jail. I think it was a full year backup for probation violation. I don't even know what it was, but he just made somebody in Delphi mad. And so he's sitting in jail and he confesses to his cellmate. Now, jailhouse confessions, everyone's trying to cut time. Apparently the guy that he confessed to, he's in jail for a long time. He probably is trying to cut some time, but they made some confessions to his jailhouse bunkmate that, weren't really public. He said he used a box cutter on the victims. He said he came back to the scene of the crime. Those things came out later. They weren't really common knowledge at the time when the confession was made to his jailhouse bunkmate. Now, are those huge revelations? I used a box cutter and I came back? I don't know, but it definitely seems like more evidence that the trial judge should have let the defense team point the finger at somebody else. If the case is so strong, why do they have to hide evidence that other people might be involved? Even if that evidence is weak, that's for the jury to decide. That's my opinion. But I did not hear the entire trial. I don't know if these guys are jumping up and down saying, hey, objection, objection, I want to get my stuff in. But the reality is, apparently one of the state's witnesses stated, yeah, the victims might have died with a box cutter. That might have been the first time the expert for the state said that. And so this confession with the new testimony, they're saying is newly discovered evidence. I don't know if that's true. But, I mean, it's a way to characterize it for sure. I don't think that's going to go anywhere. But I think it's kind of I think there's still a reason why they did that. And I think the defense team knows that's not going to carry the day. But they did it. There's also some back and forth with a new affidavit by the defense's expert saying, hey, the state's expert was nonsense. I don't see that going anywhere. The reality is the jury can listen to evidence and they can cross-examine. So that new affidavit I don't think is going to go anywhere, at least undoing the jury's verdict. Now, just because I don't think the motion to correct error is going to be successful doesn't mean they wasted time doing it. A couple of different reasons. Number one, when you file a motion to correct error, the clock stops for the motion to appeal. You just get like a pause button. And the 30 days from the sentencing now becomes 30 days from when the judge signs the order for the motion to correct errors. So this gives the appellate team more time. Now, the appellate team didn't file this motion. The trial team did. And I have no idea who's involved, and I'm speculating. Pure speculation on my part. But I'm speculating they did this to get some more time for the appellate team. Number two, there is something, trying to get the last word in. I really do believe that by filing this motion to correct error with such details, they're sending a message to the appellate team, they're sending a message to the Court of Appeals, hey, here's the issues. We weren't allowed to point fingers at other people that might have done this. The evidence they convicted us on is pretty flimsy. Put those two things together and a jury would have gotten a different verdict. So I do think by doing this, they're sending a message and they're getting the last word in before it goes up to the Court of Appeals. And number three, when you include evidence in a motion to correct errors, it becomes part of the trial record. So the Court of Appeals is going to consider the affidavit by the expert saying the state's expert's nonsense. They're going to consider this, or at least more consider the Ron Logan confession, the jailhouse confession. It just helps make a fuller record. So there are some strategic reasons for doing a motion to correct errors, which I think the defense team is doing, but I don't know. I don't talk to these people. I see them every now and then, but we don't talk about the case. So I'm speculating, but I do think there's a strategic reason why they filed this motion to correct errors. And I'm interested to see what the state of Indiana says in their response. And obviously I'm dying to see what the judge orders, although I can't imagine in 1,000 years the judge would say, you're right, new trial. I don't see that happening. If you watched this far, don't forget to like and subscribe. Leave me a comment. I will do my best to respond to every single comment, although I can't promise that because I'm just getting a lot of comments. I'm a pretty busy guy. Remember, the most important thing is, and Richard Allen probably wouldn't be in this spot if he'd done this himself, always plead the fifth.